let's talk about other consequences of not having a will. And let's make it an easy situation. Let's take a couple, let's say they've been married for, 40 years and they have a long marriage, but they don't have any children together. One of them has a child from a previous relationship, and the other one has no children. And aside from this whole characterization of what is the property, let's kind of move on from that and say, okay, let's just say it's all community property. All right. So the spouse who has a child from a previous relationship dies first. Everything is community. Everything, therefore, goes to the surviving spouse, who is the step parent of the deceased spouse's child. The relationship may be good, the relationship may be bad. I don't know what the relationship is. Here is a couple that has not done any will in the past. And now the surviving spouse owns everything. What can the surviving spouse do? They can do anything they want. It's their assets. When I say they can do everything they want, they could, if they do a will, they can do a new will that says, I wish to honor what I believe my deceased spouse would have wanted, and I will make sure that on my death, through my will, that child receives whatever, half of the estate, all the estate, whatever it may be. That surviving spouse has to do a will to provide for the child of the deceased spouse. And it's up to them. They have no legal obligation to do so. Whether or not they have a moral obligation is a matter of what soul searching they do and what they know their deceased spouse would have wanted. Did that deceased spouse want to provide for his child or not? In any event, the spouse who survives must put into place an estate plan, must have a will, must give direction. Because what happens if they don't? And this is a couple who, during their lifetime together, they didn't do an estate plan. Is the surviving spouse going to now take steps to put into place an estate plan? It's probably more likely that they will, because they recognize that if they don't, where are their assets going to go? And they may or may not realize it. So in the situation I was just describing, the surviving spouse is a step parent. A step parent means that they have no children. The child of the deceased spouse is not legally theirs. And what does that mean? And in this situation, let's say the surviving spouse does not have a will or other direction of their estate plan, their assets. Where does it go? Well, a surviving spouse is now a single person, be it a widow or a widower. So as a single person, remember what we talked about, where the assets go? It goes to their children. They have no children. It goes to their parents. Their parents aren't alive. It goes to their siblings. Are their siblings alive? And if not, do the siblings leave children of their own? That is where their assets will go on their death. And again, it will go because there wasn't any estate plan in place to avoid probate. There will be a probate again. Because of no estate planning, either while the couple were both alive or through the surviving spouse, the laws of intestacy apply in both situations upon both deaths. And that child of the first spouse to die gets nothing from their parents' estate or from the step-parents' estate. So if that is what is intended, I encourage people to make it clear through a will. Because if you don't make it clear, then you are left with a whole lot of unanswered questions and a whole lot of angst and upset. And you might say, well, who's at fault here? Well, let's go back to the very start. I'm an estate planning lawyer. You know I encourage you to have an estate plan in place, to make your wishes clear, to make your wishes known. Have an estate plan in place. either have a will or a revocable living trust, and make sure you administer it correctly, because that's the problem with revocable living trusts. But make sure that your wishes are known. If you don't want to disinherit your child, in your will, say, on my death, all of the assets that I can direct, all my separate property, all my community property, either A, goes into a trust for the benefit of your spouse, and then on the surviving spouse's death, the trust says it goes down to your child. That's one option. Or else you could also say, on my death, certain assets go to my child, and other assets go to either outright to my spouse or to a trust to my spouse, and then down to my child. Just put into place some protections if you truly want to make sure that your child and your grandchildren inherit from you. You have to take action to make that happen. And if you haven't and you pass, then that is up to your spouse, whether or not they will take any actions to carry out those, what your interest may have been. And again, there's no legal obligation for them to do so.